Well, welcome back to TuckerAllen Live. I'm Scott Trout, and I'm your moderator. And we'll do the same thing every Friday at the same time. And we want to spend about 10, 15 minutes with you, just bringing you information about wills, trusts, estates, all that. And I'm joined by our Independence, Missouri attorney, Kevin. Welcome back.
Thank you so much for having me, Scott.
So as usual, we try to break down, complex things with big legal terms, and today's going to be no different. We're going to talk about decedent's spouse's debts. So maybe we just start, let's define each thing, define decedent, define estate, and define distribution, and then we can kind of talk about how that happens, because everyone wants to know what happens to debts when someone passes away, and this is a good place to start. So maybe define it. Let's kind of go from there.
Sure. Decedent is the person who has passed away. So they're the person that is deceased. So that's what that term means. It's a term of art, I guess, that's commonly used by lawyers and not so much by everyone else.
So in terms of the decedent, it is someone who's passed, could be a relative, could be a friend, and maybe you want to know what's going on with the estate. So the estate is what they have?
Yes. So the estate is just the entirety of all the assets that they owned at the time of their death, or, if life insurance is involved in that, life insurance policy could also be a part of their estate. Yeah, it's just their assets. It's a fancy word for assets.
Yeah, right. So let's talk about what happens with your loved ones, your friends, your family's debts when they pass away. Maybe that's the first place. And let's start from that. Let's say we're going to use that word decedent again, or my friend or my family member. What really happens when they die? Am I responsible? Is the family responsible? Who would normally, because inevitably, I would think a lot of times someone dies with credit card debt. And what's going to happen with that? Who's responsible? That's a worry for a lot of people.
Sure. So you're absolutely correct. I did a little bit of research about how many people pass away and still have debt. And, almost 3/4 of Americans at the time of their death do have some sort of debt. And it's a pretty substantial amount of debt on average as well. So like you were saying, though, talking about credit cards in particular. If the credit card is solely in the name of that decedent, the person who's passed away, then there's no responsibility on anyone else's part to pay their debt. So just as a general rule, no one is obligated to pay the debt of another person, of a third party, someone that's not themselves. So if that person who's passed away, you're not obligated for their debt. So there are some exceptions to that, but the Federal Trade Commission, as well as another, it's called the Consumer Financial Protection Bureau. So that would be more along the lines of those credit card debt ideas. They all have come out. They've all confirmed. They've all said, third parties, their job is not to pay the debts of that person who's passed away. And then, there are some exceptions to this rule, but just the broad general sweeping rule is that there's no duty.
So the most common situation where people I know will have questions, it's their spouse. My husband died, my wife died, and they're concerned about debts. Now, does that same rule apply to spouse, even if because we talked about friends, and that seems maybe obvious, maybe a distant relative seems maybe more obvious, but does it really change if it's a spouse?
So nope, it does not. It doesn't change if it's a spouse. So then this is kind of where a couple of those exceptions are going to come in, though, to that rule of that generally you're not liable for someone else's debt. So with spouses, a lot of times their debt is each other's debt as well. So that's, if you co-signed for a joint loan for your home, maybe would be an example where that was their debt, but it's also your debt. So it doesn't dissolve. You still have to pay that debt. Or if you had also signed on a credit card with them, that would be another example then to where you were the co-owner of this credit card account, then you would still be liable for it. But if your spouse just had this credit card on their own, your name wasn't attached to the card, then no, as a spouse, you would not have any duty to pay off their debt from that credit card.
So, I mean, we've talked, I think, even at the virtual town hall this week, the importance of collaborating with your financial advisor, or certified financial planner. And is there a way, because now people are thinking, okay, but what if, we use the word estate, has assets within which to pay the creditors? Are there ways that there are some assets that would not be subject to creditors' claims, or is there a way to avoid that? Because we can't just say, nope, you're not responsible. Maybe that's from the personal standpoint, but is the estate responsible?
Sure. Yeah. So that the decedents, the person who's deceased, their estate is going to be still responsible for those debts. A lot of times as a spouse, you may be the personal representative of your deceased spouse's estate. So you would have a duty to inform and then pay creditors. But with that, so a caveat to that, though, is that the person's estate, if they're your spouse and they're deceased, their estate is only going to include things that they owned individually. So if you had real estate that you jointly owned, then that becomes yours alone now that your spouse has deceased. If you had joint bank accounts, a joint brokerage account where you made investments, all of those things are not going to fall into their estate. They now just become owned solely by you, the sole living spouse. So those things don't make up the estate. The creditors cannot get to those because you own them. And so that's kind of a big point as well, because a lot of times, the people that come out to try to get the money for the creditors, they might not be the most scrupulous humans on the face of the earth. And they might be saying otherwise. They might say, no, we are still owed that, even though you were a joint owner on this account. And that's just not the case. And then there's quite a few other things as well that fall into this exception that creditors really can't attach to, would be what I would say. And by attach, I just mean that they can't get from you. So one of those would be like a life insurance policy. I'm sorry, I had to write them down because I had a little bit of a list here. So like a life insurance policy would be one that they can't really attach to. Disability benefits, if your spouse had those and you were still getting some payments from that. Employer sponsored plans, so like a 401k would be another. And then retirement accounts. So those are all things that creditors can't really attach to. They might say that they can, but
right. Well, they'll threaten it, right, to gain leverage, right?
Correct.
I mean, I guess that's the whole point of working with a financial advisor is, hey, maybe there are assets we want to put in your spouse's name rather than your name, because from a financial planning standpoint, and that's why it's always good to kind of use this as a team.
I wasn't really avoiding it, but I'm pretty good at procrastinating. I needed a trust. When I found TuckerAllen, all our questions were answered, all of our fears allayed.
You want your wishes in place, so there's no guessing, no stress on the children.
Basically, they talk about what you need, what's important to you. It was more conversational, really very simple.
Now that begs the question, if an asset's titled in the surviving spouse's name only, is that subject, to the rules or the suggestion you made earlier that you don't have to pay the debts of the decedent?
Yeah, so if you have a beneficiary designation, which we've talked quite a few times about on here, if you have that beneficiary designation going to the now living spouse, then yeah, it becomes theirs. It doesn't pass into the decedent's estate. So now you own it, and that's also something that cannot be attached to by a creditor. So it makes it sound almost as if these bills from the creditors, that they just disappear, which they don't. They're, let's say, for example, that I was married and I had a car that was solely in my name and I didn't have it TOD to my spouse, then that would be something that would pass into my estate, and that could be something that could be attached to by creditors. But so that is an example where it could happen.
So yeah, that's where, if I understand it right, make sure, because I know they'll watching have the same question. So if something is TOD, let's just call it a bank account. and it's the surviving spouse, and there's a medical bill that's hanging out there. And once the death happens, that automatically transfers to the surviving spouse by designation of the TOD. Can the creditor use that account now that's owned by the surviving spouse to force her or him to pay the medical bills?
No, they cannot. So again, that might be something where they could threaten to say that, yes, we can attach to this, but since it's not passing through the estate of the decedent, it is being directly passed to you, then no, it's not in their estate. And that's where the creditors can pull things out of the estate, which again is those assets that the person owned at the time of their death. But if you own assets that, like with the TOD or the POD designation, then they don't pass through your estate, would be a way to say it. And since it's not passing through your estate, then they can't be attached to by that creditor.
So that's important. I mean, it's a huge distinction and difference for people, and that is the importance of the TOD and making sure that does pass around. And whether it be rent on an apartment that is due under a lease terms and there's no assets that are going into the estate, they're all automatically TOD transferred. That's a great position to be in, because I get it, as you suggest, you have these creditors who'll call and say, well, you owe it, and if not, I'm going to come after your account. It's not actually accurate. It depends on how things are titled and how they passed, right?
Yes, absolutely. And like I was saying earlier, a lot of times the people who are making those phone calls don't have a lot of qualms about making those sorts of threats to say, hey, we're going to do this unless you give us some money. And, a lot of times those threats are empty threats.
Yeah, totally. And I mean, that's the point. Work with the financial advisor, get your team together with your estate planning attorney and your financial advisor, who may be a certified financial planner. Start thinking about how things should be titled. Where should they be placed in the event of death? So as to minimize exposure, not only, plan for long-term care, maybe plan for benefits in terms of paying for long-term care and reducing your estate to ensure that you qualify, but making sure you can make sure that those debts upon death, that they're not to be paid by the surviving spouse. So that's huge. So to kind of, as we get close to the end, what happens if there's no joint owner or beneficiary at all on assets?
So if there's no joint ownership, if there's no beneficiary on this asset, then what happens with that asset is it has to go through, if you have a will, it's going to go through probate, or if you have a trust, then it's going to have to sit in that trust for a little while either the personal representative or the trustee, they have to publish they publish, basically saying this person has passed away. If you're a creditor, now is your time to come forward and tell us that you're a creditor. And then as the trustee or the personal representative, I'm going to look at your claim. And if we have the assets, then we're going to pay you off. So that's how that kind of works out. So then it's prior to distribution, you must make sure that the things that the creditors can attach to and get their money from, that you go ahead and do that. But our goal is to not have a lot of stuff hanging out that creditors can attach to.
And that's what we talked about at the virtual town hall, was ensure that you have those things, funding to make sure that things that are required are placed properly, titled properly, put, in one basket or protected in that way. And so I think if, you're watching, you're thinking, okay, I've got my will, I've got a financial advisor. Well, that team needs to get together at some point, or maybe you don't have one piece of that puzzle. If you don't have the financial advisor, you need to make sure you get that. Let's make sure they're invested properly, make sure that they're covered properly. And let's make sure that your wishes for what you want to be done with your money is taken care of. And also thinking about what happens with bills and who can be attached and what falls into an estate, to make sure, which is that legacy protection program we talked about yesterday. And if you're watching, you haven't heard of it, go to TuckerAllen.com, find out more about it, give them a call. It is a way that you can ensure year in and year out that things that you acquire over time can be funded appropriately, titled appropriately, and prevent situations just like we were describing today, where you might be able to attach to it and creditor claims could be successful. So Kevin, thanks for joining as usual on TuckerAllen Live on Facebook. I really appreciate your time on this.
Thank you so much.
So continue to check us out each week, every Friday, same time, same place. We'll just bring you 15 minutes of information Once you write down, go have a conversation with someone who practices exclusively in estate and elder law, and then find that financial advisor and get your team together so they can work together to accomplish your long-term goals as well. Check out TuckerAllen.com, give them a call. You can schedule a consult right there. In fact, you don't even have to go into the office. You can do it from the comfort of your home, or you don't have to go into their office. You can do it from your office or your home, right on your sofa, wherever it is, or if you want to, where it's safe, where it's appropriate. You make that decision. You can schedule that consult by going to TuckerAllen.com or give them a call. So until next week, same time, same place. We'll see you then. Have a great weekend.